Welcome to another edition of the LegalRiver podcast, a weekly look at the laws and legal issues facing small to medium-sized businesses.
My name is Kevin Learned. I'm chairman of the corporate practice group at General Counsel PC, a full-service law firm in McLean, Virginia. Today we're going to talk about entity choices for new businesses. One of the main things people always ask when they're starting a new business is, what sort of entity should I use? The primary entities people hear about are sole proprietorships, partnerships, limited liability companies, we'll call those LLCs, S corporations or S corps, and C corporations, C corps. So from the start, we're going to strike partnerships and sole proprietorships from our discussion. The issues those entities have are they do not provide liability protection to their owners. So if there's any kind of losses at the entity level, those flow directly to the individual owners. So they're not good choices for new businesses. So again, we're going to focus on the last three entities, the LLCs, the S corps, and the C corps. So this is not going to be an exhaustive discussion of the entities. It's going to be kind of a primer giving you some of the major points of discussion among the three types of entities. The exact entity you choose to use is going to vary on your specific circumstances and will need to be done in discussions with your legal counsel and also with your accountants. So the first issue we'll talk about on these entities is the way taxation plays into it. LLCs and S corps are what we call pass-through entities, which means all of the profits and losses from these entities pass directly to their owners. The entities themselves do not pay taxes. So instead, as the entity earns income, that income is passed on directly to the owners, and the owners recognize that income on their personal income tax, on their personal returns. Distributions of money from those entities down to the owners are generally not taxable. So there's tax just the one time. These entities are very good in cases when you have an entity that does not generate a lot of net income, therefore there's not much income and therefore not much tax liability to pass down to the owners, or at the very least it generates enough cash to pay the tax liabilities that are incurred by the individuals. The way these two entities differ from the C corps is the C corp itself does pay taxes. Currently the C corps pay tax rate, it's graduated, but it's roughly 35%. So as the corporation itself earns income, the corporation pays taxes. Then, if the corporation distributes cash down to the stockholders, there's a second level of taxation. Now currently that level of taxation isn't very high, it's about 15%. However, possible changes in the tax code, that 50% number is very likely that it can increase in the future. So these entities are best suited for corporation entities that do not expect to distribute a lot of cash down to the stockholders, or don't have a lot of net income at the corporate level and have cash that can be reinvested into the company. Now there are some tax benefits to the C corp, so don't get me wrong, the double layer of taxation isn't necessarily the worst thing. C corps have certain deductions that are not available to LLCs and S corps, such as ability to use passive activity losses. So again, it's one of those issues you need to talk with your accountant based on your specific situation as to which one makes the most sense from the tax perspective. So the next issue we're going to talk about is ownership structure. LLCs are probably the most flexible when it comes to how you structure the ownership of the entity. In particular, you can have multiple classes of stock, or in LLCs we call them membership interests. You can have different distribution amounts or priorities among the members. You can separate voting interests from economic interests. There's a lot more. Basically, any business term you can think of, you can set up in an LLC. On the opposite extreme, S corps are probably the most restrictive. You can only have one class of stock, so you cannot have priority distributions among members. All owners in an S corp must be individuals, so you can't have entities as owners in an S corp. There's a few exceptions to that. You can have some family trusts, and there's a few other exceptions, but for the most part it's individuals. You also are restricted on the types of the residents of those individuals. They all must be U.S. residents. You can't have foreign owners in a S corp. There's also a number limitation. You can only have 100 owners in an S corp, although for most small businesses that's not a concern. C corps are a little bit in between. You don't have the same restrictions that you do on the S corps with respect to numbers of owners and with respect to classes of stock. But at the same time, there is more structure than you have in an LLC. C corps have been around a lot longer, and there's a lot more corporate niceties that have developed. You have a board of directors, you have stockholders, and that sort of thing. So the related issue to ownership is management. Again, LLC is much more flexible. You can have the LLC just managed simply by its members. You can appoint a manager to manage the business. You do not have to have officers. There's no specific way in which you have to structure the management of your company. S corps and C corps, on the other hand, much more structured. You have stockholders who appoint a board of directors. The board of directors appoints officers. Usually, almost always, you need a president and/or CEO, and you need a secretary, and the entity is controlled by those individuals in their officer capacities. So there's a lot more structure into the C corps and the S corps than there is in LLC with respect to management. The final topic we're going to discuss is exit strategy, and which entity makes the most sense depending on how you want to eventually get out of the business. We assume from a sale to a third party. LLCs are the one entity. This is one of the few places where the LLCs are less beneficial than the other entities. Institutional investors and strategic buyers often aren't familiar with and are not comfortable purchasing LLCs. They much rather purchase a C corporation. LLCs can in fact convert to a C corp status. However, that has negative tax implications. It's considered a tax dissolution of the LLC. This may or may not be an issue for your business, but it's something to think about. S corps, on the other hand, even though if they're bought by, say, a third-party company, which cannot be an owner of an S corp can simply lose its S corp status, become a C corp. It doesn't have the same negative tax implications that an LLC does. And then C corps, of course, are the preferred vehicle for a third-party acquisition. And in fact, if you are so successful that you try and take your company public, all public companies must be C corps. So again, that's looking down the road, but it's something to definitely think about. As I noted, this has been a general discussion of the issues with respect to entity choices. This is not meant as legal advice. If you have specific questions or issues, please consult legal counsel. You can also direct any questions or comments to questions@legalriver.com, or you can contact me directly at klearned@generalcounsel.law.com. Thank you for your time, and I hope you found this helpful.
Thanks for listening to this edition of the Legal River podcast. If you have a business law question you would like to see answered in a podcast, please email us at podcast@legalriver.com. To reiterate, all views expressed in this presentation are intended only as a general discussion of the issues and should not be regarded as legal advice. For additional details or advice about a specific situation, please consult legal counsel directly.